Hello and welcome to tonight's Reasonable Doubt, hosted by the Harris County Criminal Lawyers Association. I am your host, Murray Newman, and with me, as sometimes always, is Justin Harris, our treasurer extraordinaire and a co-host for life. No matter what he said.
I'm treasurer for life.
Treasurer for life, co-host as long as I'm here.
Yeah, okay, all right, appreciate that.
We have got an interesting episode tonight because it's rare in the history of HCCLA's Reasonable Doubt. I don't think we've ever had a two-parter episode. But on August, we had an episode where we had guests Janie Maselli Woods, her husband Ted Wood, and former Harris County District Clerk Chris Daniel as guests. They were talking about the topic of uniform judgments and errors that were existing within those forms as generated by the District Clerk's office. Shortly after that episode, I was contacted by David Mitcham, First Assistant of the Harris County District Attorney's Office, letting me know that there was some wrong information in that and asking to come on and address that. The way I was raised, if we make a mistake, we own up to it. I supported Kim Hogg in 2016, for instance. But we can say these type of things, and we certainly want to give an issue to both sides of the story, along with David Mitcham. First of all, welcome, David. Thanks for coming on.
It's good to see you, Murray.
Good to see you. We also have my longtime friend, Christine Baldwin of the District Clerk's office. And we also have Tracy Hopper from the District Attorney's office.
District Clerk.
I'm sorry, District Clerk. You know, too many districts. So, David, why don't you lead off? First of all, your District Attorney's office, but you took issue with something when we were talking about District Clerk's office.
Well, I was referenced in the broadcast.
But not by name.
No, but it was specified.
Okay.
And we'll get into that. But first, I want to thank you, Murray, and the Harris County Criminal Lawyers Association for giving us a chance to respond to what we believe and what we know was some misinformation that was broadcast on August 29th in the Reasonable Doubt episode at that time. I do appreciate it. I'm sure Miss Baldwin and Miss Hopper do as well. They're here from the clerk's office. We want to get this straightened out. There was some misinformation both of law and fact. And unfortunately, the misinformation of fact devolved into defamation and slander.
Okay, and you've retained a lawyer on this.
I have retained a lawyer.
Okay.
And I've consulted an attorney.
Okay.
Do you feel like the slander and the defamation was directed at you individually?
Yes.
Or the
Well,
office you work for?
both.
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 Did the lawyer that you retained to represent you, does it represent you personally?
Personally, yes.
What about, does anybody in the office have representation regarding this matter?
Not to my knowledge.
Okay.
Nobody else in the office was specifically referenced in the broadcast.
And you weren't specifically referenced by name. You're saying you were described?
I was the husband of the chief of staff of the clerk's office that was referenced in Mr. Daniels' speculation of criminal activity.
Okay. Okay. All right.
Let me pause real quick. I am getting comments that there's some audio issues. I am told Tate Williams needs to mute himself. There may be. We're trying to.
That's Zoom.
That's on Zoom. Yeah.
On the
Okay.
TV show.
Oh, okay.
All right. Sorry about that.
All right. Well, in the broadcast on August 29th, you had your three panelists, Ted Wood, Janie Maselli Wood, and Chris Daniel. And there was a number of things that were broadcast that we take issue with.
Okay.
It all surrounds the part of the judgment that's used in criminal judgment forms,
Right.
with the language of after having conducted an inquiry into the defendant's ability to pay. That was the central bone of contention that arose during the broadcast. But there was also a legal matter that I need to address because Mr. Wood addressed it, and with the passing of time, there's been substantial change in the law. It was clarified by the Court of Criminal Appeals in Austin.
Well,
three words
to the heart of what can we get to the heart of the issue?
Sure. What he was claiming was that this right to a ability to pay inquiry by the court is a fundamental right. And we took issue with that at the district attorney's office, and there was a case that came before the court, State of Texas versus Martin Cruz. Very briefly, Mr. Cruz and a couple of his associates took a gun, put it in a woman's face, abducted her, sexually assaulted her, and were ultimately rounded up, and a jury gave Mr. Cruz 30 years and an $8,000 fine.
I'm sorry to pause again. Mark, I'm getting comments on Facebook that there's no audio, just FYI. So,
all right.
I know you want to be heard, but
well, theoretically,
it's being broadcast live over the air to anyone who has City of Houston cable.
HMSTV.org
right.
stream.
You can also go to HMSTV.org. There's a stream there. Sometimes there's apparently a Facebook
issue. They can't hear that.
Right. So maybe somebody who's on HMSTV.org or...
is there any way we can put that on the screen, Mark?
I'll try.
Okay. Sorry, man.
There is audio going out, though. It's just sometimes the Facebook end of things doesn't pick it up.
Okay.
Gotcha.
I'm sorry about that.
No problem. Essentially, there are three types of rights you have in Texas in the criminal context. You have structural rights, you have fundamental rights, then you have standard rights. And then what we'll be keying on in tonight is fundamental rights and standard rights, because that was what was at issue in the Martin Cruz case. Mr. Wood took the position and argued before the court that it was a fundamental right to have a inquiry by the court as to indigency and an ability to pay. The District Attorney's Office of Harris County took the position that no, it is a standard right, and the right to such an inquiry is not fundamental to the adjudicatory process. 3 working days after the broadcast, the Court of Criminal Appeals, through Judge Keel, laid down their opinion, and in their opinion, they agreed with the Harris County District Attorney's Office and our able counsel, Chris Conrad, that the inquiry that the legislature has mandated for the courts to do a inquiry as to the defendant's ability to pay in every case is a standard right. And what that means is that the monkey is on the back of the criminal defense attorney to assert their client's rights. And if they have a problem with either the court not giving an inquiry or how the inquiry goes, you've got to get on your hind legs and object. Now, if it's a fundamental right, as Mr. Wood was contending, you would not have to object at the trial level. You could do what lawyers call lay behind the log and bring it up for the first time on appeal. And that would enable the defendants to raise this issue on appeal. But the Court of Criminal Appeals determined that this was a forfeitable right. If you don't assert it, you forfeit it. And okay, so that's the way they ruled.
Ted, the defense litigator on the Cruz case?
Yes.
And okay, all right. So you guys won in the CCA.
Right.
Okay.
Well, and with this,
but that's not what we're here tonight about.
Well, with this caveat, Mr. Wood has filed a motion for rehearing, and so I guess it's possible, kind of like in the movie Dumb and Dumber, he's got a chance, and he gave it his best shot. But the court says no, it's not a fundamental right.
Right.
And that plays into a number of matters that came up in the August 29th broadcast.
But so you mentioned 3 business days after this. So here's what I'm trying to get us to is you called Murray's office 1 business day after?
No, it was actually a week.
No.
It was like a
week after?
Yeah,
okay.
It was the...
And then you called like Murray, our former president and current co-host of the show, into his office and very strongly said you had a right to come on our show.
I did not. I requested it.
Okay. And we've extended that to you, but I don't know that we're here, and Murray and I have been talking about this for a couple weeks about what the CCA is going to decide on that case. You're here because you feel like, even though your name was never mentioned, you say that because of who you're married to, that was invoked in some way.
I don't say it, it was.
Okay.
But
All right, and let me address your issue, Justin, and how I got involved in this
Please.
this issue.
Yeah.
On Thursday, a week after the broadcast, I got an email from Gary Zoller, who is our IT specialist at the district attorney's office. He said, "Man, you got to look at this." I could not get around to doing it on Thursday, but I made a mental pact in my head that I would not leave the district attorney's office Friday until I actually watched Reasonable Doubt. And I don't get to see Reasonable Doubt as much as I'd really like to, but
you and the rest of Houston.
Yeah.
Go
right.
ahead.
But at any rate, about 6:30 at night on a Friday, I did watch it, and I was stunned and appalled. And when I saw it,
By the misstatement of it being a fundamental right versus a standard right?
no, with the allegation that my wife and myself tampered with a government document.
Did you do that?
Absolutely not.
Okay.
I had
was
not
that-
even heard.
But was that said?
Yes, it was. I will be able to reference it to you.
It said, you have not said your wife's name, so I'm not going to do that. But
No, it's Judith Snively. She is the chief deputy clerk over the courts with the district clerk's office. And this has to do with the forms that are used in the criminal courts for the judgments. On February 23rd of last year, the Office of Court Administration promulgated a number of changes. It affected 7 judgments, judgment forms, and it involved 68 different changes. The clerk's office was given from February 23rd to September 1 to make these changes.
That's statewide.
Right. This is a statewide matter.
So the OCAs in Austin, they told all the clerks around the state, make these 68 changes on these 7 types of judgment forms.
Right, by September 1.
By September 1st. So
Right.
all were trying to comply with the deadline like everybody else.
Yes.
Gotcha.
And then the clerk's office, they got wind of it and flew into action. And in July, they amended the forms, and they did it in 67 of the 68 areas that had to be amended.
The district clerk's office.
Yes.
But at this
And
point, your office has nothing to do with it.
absolutely nothing to do with it at that point.
Okay, but you want to keep telling everybody what your office didn't do and what the district clerk's office did?
I'd like to be able to state my case in the same manner that the previous panelists did without constant interruption,
Okay,
Justin.
understood.
All right.
well, now hang on.
Well,
This is our
no,
show. We don't-
And I wasn't
gotcha.
here that day, and if I had questions for Janie, Ted, or Chris Daniels like I have every time they've been on the show before, I'll speak up and ask the questions.
All right, fine. At any rate, the clerk's office fixed, pursuant to the Office of Court Administration, the changes, but they missed one line, which on the judgment of conviction by jury, the line "after having conducted an inquiry into the defendant's ability to pay" was left in inadvertently. It was a clerical mistake, and that was that. In March of 2024, Janie Maselli sees the phrase in a judgment and alerts the clerk's office that it needs to be removed consistent with the dictates of the OCA.
And Janie Maselli is the chief of the appellate division for the Harris County Public Defender's Office,
That's
right?
my understanding.
So that's kind of like the kind of thing that would fall on her radar.
Sure, sure.
And that's the appropriate thing for her to do when she notices that, to call the clerk's office.
Absolutely.
Okay.
And Miss Baldwin, she's one of the managing clerks over at the clerk's office. It was in her bailiwick to get this done. As soon as she got word about it, she reviewed the judgment at issue, and she said, "Yeah, we missed that," and responded to Miss Wood that she's right. There was an email where she said that they've discovered the error and they're fixing it. They got it fixed within a day, and it was human error. And that was that. And then it went off the rails. Miss Wood was of the opinion that it couldn't have been a mistake. It had to be intentional. And if it's intentional and you're tampering with a judgment form, that would, of course, be a crime. And of tampering with a government document, either a third degree, or if you're doing it as part of a conspiracy, or 3 or more, it could be up to a second degree. All right, so when she sees it, she forms the opinion that it was intentional, and then proceeds to issue an enormous number of PIA, public information requests, looking for the conspiracy to take the offending language out of the judgment and then criminally put it back in. That is her theory of what occurred. That did not occur. And we can factually show that it did not occur from the digital evidence that has been examined by both Ms. Hopper as well as Gary Zoller. It simply was not the result of a conspiracy to defraud and to tamper with a government document, which is what she accused.
Well, let me pause you real quick, because I was here, Justin was not. And as you and I spoke in your office, obviously I was the person sitting there kind of learning a lot of this as it was going along. You would agree with me that, number one, that there is an interest that an appellate attorney would have in looking at avenues to create an appeal for a new trial for their clients. And you would agree with me that Janie Maselli Wood is someone who's extremely diligent when it comes to that, and that this and fines and fees for indigent clients have been topics that she's tackled before, correct?
I'll take that as true if you tell it me.
Okay.
I'm not sure.
I mean,
I'm not familiar
with
with the issue prior to the August 29th broadcast of Reasonable Doubt.
You would agree with me that this was not exactly a real sexy issue to talk about, to go after, when we start talking about fines and fees.
Yes, because in Harris County, it's pretty much of a phony issue, because there is not anybody pretty much. It takes an outlier case. You can never say with criminal law for sure that 100%, but by and large, people are not being locked up over fines and fees in Harris County. The prosecutors don't care about it, neither do the judges.
But you were a defense attorney long before you were a prosecutor, then a defense attorney, and then you came back. You know good and well that as defense attorneys representing our clients, we can't just make that assumption or tell our clients that like they never really enforce that. We don't do that. We have to tell our clients what could happen to them. We don't sign a client up to a PSI where they could get 5 to life and say, but the judge will never do that.
I totally agree with that, Mary.
You would agree with me then that if she is looking at something, because this is, to the best of my knowledge, as I understood what Janie was saying, was that this is a document that is reflecting something that is inaccurate in court. And basically, and this is, and I could be wrong on this, I'm going off memory, and I'm not an appellate attorney, but my understanding from what Janie and Ted were saying was that the judgments that are coming out right now are reflecting something that did not truly happen in court. And I recall, and I agree with you on what you said earlier, that there is an onus on the defense bar, the defense attorney standing there to ask for that finding, because my reaction to that was, oh God, am I screwing this up? Am I not doing my part on this? And so you would agree with me that what Janie and Ted are bringing up are highlighting something that she at least is perceiving, whether wrongfully or correctly, is a big issue. Because if you are having a finding that something happened in court that did not happen, what do you call that? I mean, if you are having a document that is basically being generated by the district clerk, I mean, I don't think, I do know that we threw around the term tampering with evidence. I don't think anybody said definitively, and I may be wrong on that, that like,
you are wrong on that.
That David Mitcham guy, he tampered with some evidence. I don't recall that being said.
No, not
But I recall thinking, like, what is this? Because it can't be right. And I want to ask another question, because we do have the opportunity to have y'all, because there's one of the things that concerned me is another issue. It wasn't addressed on that show, but recently, and I do want to look back to this in a minute, about how the district attorney's office is working hand in hand with the district clerk's office on judgments, because I am curious as to, you know, how the sausage is made on that. But a thing that I have realized recently, and I didn't realize it, is that we get plea paperwork that is handed to us electronically by the district attorney's office. We all agree on that, correct? Correct. And in many different courts, we go over that, especially for our clients that are in a holdover or don't have access to see that, and we read it to them. Maybe we have an iPad, we show this to them. And a lot of times these clients are brought up to a kiosk and they sign their names, and that is applied to all the paperwork that we just went over with them. Correct?
Correct. And
there is a representation that the district clerk's office is making at that point that this has all been gone over with them, and they are signing this because they are aware of this. Recently, we've been made aware in HCCLA of this admonishment about you're not allowed to possess a firearm anymore. And that is not part of what, do we agree that that's not something that comes from the district attorney's office? That is not, when you all do your plea paperwork, that is being handed to us, correct? There's no firearm admonishment when the DA's office gives us that electronic paperwork. That is not something that we go over with our clients.
You're talking about what we get to go over with our clients.
Correct.
The 5 or 6 documents.
We get the admonishments, waiver of indictment, right to appeal, discovery log, discovery warrant.
We don't get the judgment.
We don't.
The judgment gets created afterward from everything else.
And so we receive these documents, and we go through them, and this is what you're signing. But now there's this additional document that is being put into the record along with the judgment that is some sort of firearms admonishment that we never saw, and that our clients never saw, that we never went over with them. Some judges may bring it up and some don't, but they never saw it, but their signature is being applied to that document. Are you aware of this?
I am not aware of
that. I think I have a little bit of information. So I know what you're talking about, and it is that admonishment. When we were first made aware of it, we were advised that and I can't remember the whole logistic piece of it, but we were told that any person who was convicted of a felony were to have the firearm admonishment. In the processing of our forms, and I'll get to that in a little bit, we do have 2 clerks that process forms, and so on felony judgments, they were attaching that as a document. I think it was an issue that you brought up in court.
I brought it up.
And as soon as I was made aware of it, I told them remove it and only add it if there's actual admonishment in court.
It's back now.
Yeah, it's in there again.
It's back now, and it's on everything. And the reason that I was first brought to it was we had a guy, another attorney, a member of HCCLA, brought to my attention that he had a guy charged with aggravated assault.
Right.
And he pled non-family violence, and he pled to a misdemeanor assault. This guy goes and looks at his paperwork later, and here's this admonishment saying he can't have a gun, but legally he can. But the more concerning thing is that his signature has been applied to this document. That he never saw, never agreed to, his attorney never saw, the judge never warned. And so, I mean, David, I understand why you're upset, but well, hang on, okay. Just let me finish this thought, because you know I'll lose it.
Yeah, please go for it.
But at the end of the day, you know, when we're seeing things like this, we're like, what do we do? What do you call that? What do you call it when something that is untrue or signed that wasn't true? I think those kiosks are going to be the death of us all.
Yeah.
But what do you do? What do you do to remedy a situation like that? What do you call it? I mean, I understand being offended at the term tampering with a government document, but what do we call that? You know, I mean, is this just like our bad situation, or is this something that somebody could be held liable for?
In my view, it might be something that they would be held liable for in error, and that if that's going on, that needs to be addressed and corrected. I didn't come prepared to address that issue.
And I understand.
Because I wanted to address the issues that were raised on August 29th by your panelists.
And I was very clear with you that we were open to talk. We would talk about this, but we were also open to talk about everything else.
Sure.
But the reason that I bring this up is because when we see this, because quite frankly, I think that's horrendously egregious that you're taking an incarcerated person and applying their signature to a document that they never saw. I think that that's pretty. I think that is bordering on something. And since now I'm scared. I'm scared to label what crime I think that is. But when we see that type of thing, we start having issues of like, what else is the district clerk's paperwork doing?
Have you brought that to the attention of the presiding judge?
Yes.
Was that ferreted out in a hearing and to determine the
but the problem is in a hearing, because we don't even know it's there until the only reason I knew it was back was I had a client that asked me what his credit was, and when I went back and looked up his credit, I was like, what is this piece of paper? I'm talking about like 2 weeks later, because no one's even notifying that it's being put in there.
Right.
So, I mean, I have to say that issues like that do make us concerned over what is the remedy and who is policing something if a document is being generated by the district clerk's office that reflects an untruth in court.
Well, we certainly don't want that to happen.
You would agree it's a public interest issue, that we should be concerned. And that if Janie Maselli did perceive that this was something that was done and something was being reflected as untrue, that would be something that she should, as an officer of the court, bring to the attention. And if she's wrong, we can say she's wrong.
I don't take issue at all with bringing the issue to the attention of the proper authority, being the district clerk, to get the mistake corrected. What I have a issue with is when Ms. Maselli makes the statement that mistakes happen, yeah, but in this case it was willful. It's not a random mistake because all the other minor changes were left. They deliberately went in and added that sentence. That is factually not true.
She could, based on what she's laying out there, that these minor things are done, the research he's done, because Chris Daniel, for the viewers who don't know, he's the previous district clerk. He also knows how like the sausage is made.
I would take issue with you with that, Justin, because what he broadcast on your program indicated that he does not know what sausage is being manufactured in the district clerk's office to date.
Do you have a better grasp of that, you think?
I have people with me right here that do.
But I'm not, right, I know, because they work for the clerk's office.
Right.
Do you know, as someone who doesn't work for the clerk's office, you think you have a better idea how the sausage is made than Chris Daniels?
Yeah.
Okay.
I certainly do.
Is that because you're married to the first assistant?
Possibly, I guess, but I'm aware of what's going on in court.
How did you get Ms. Baldwin and Ms. Hopper here? Or how did this come together?
Because you
told us you were bringing 2 people from the clerk's office and you were coming, and we found out today the names of who was coming.
Well, I knew Christine was coming.
So I just how did this come together?
Well, whenever Ms. Maselli accused the clerks of committing crimes, it got our attention at the district attorney's office, mainly my attention, and I wanted to make sure that wasn't occurring.
So Ms. Maselli, your perception is Ms. Maselli said that there's some behind-the-scenes conversations going on between the district clerk and the district attorney's office and about false information, and then you went and had behind-the-scenes conversations between the clerk and the
Absolutely not. What Ms. Maselli said was that
all these documents. I mean, Murray, have you had anybody come on the show with this much preparation before?
Janie.
Yeah. So it feels like they struck a nerve. And what you're describing is this is a TV show where we talk about stuff in the courthouse. And so Janie came into the show and said, there's something going on in the courthouse that I think the public should know about. So, and I have the application here for Houston Media Source. Like they give us a time in the community issues slot. So that's what the conversation was. And I mean, I understand that you're upset that you feel like somebody said something false about you. Believe me, I know how that feels, but it's like you're telling everybody, you're setting the record straight. You didn't tamper with anything. There's no like malfeasance going on behind the scenes. But can you see, especially even this whole setup, how we might think that?
Maybe, but I'm here to clear that up.
Great.
Okay,
but I don't think that makes anything
And we
slanderous.
are giving you that opportunity,
I know.
and we're going to let you talk again, I promise.
Okay.
But at the end of the day, David, every day a case gets dismissed in a court.
True.
Where you all have identified someone by name, you've even scooped them up out of their home, their car, their street, and you've brought them in and you have accused them of something that was wrong, and there was a public interest when that happens, and then it ultimately gets dismissed, and that is what happens when there are issues of public interest. And the district attorney's office, and I'm not trying to get too far afield, has made a lot of comments during the Kim Ogg administration about a lot of people that haven't had their day in court about what they perceive as true and what they think is going to happen, and what law was broken. So what's the difference between Janie Maselli seeing something that she believes is something that could possibly constitute a crime, or even saying it is a crime? When y'all arrest people, you are saying that's a crime, and then being proven wrong.
Well, the system is not perfect, and not everybody that gets arrested is guilty. They're entitled to their day in court, obviously. They're entitled to the presumption of innocence and all the other rights that we have as Americans. And it's not a perfect system, but it's the best we got to work with at this time, and we try to do the best we can.
But you're here to address an accusation that you believe was targeted at you and your wife on a cable access show that maybe had 30 people watching it.
Well, but it's been recorded, and it's the community in the courthouse. And I've been a lawyer for 45 years, and no one else in these 45 years has accused me of tampering with a government document. And I want to clear it up because it didn't happen.
And do it.
Okay. And what we're addressing is Miss Maselli and Mr. Daniel and Mr. Wood, because they acted in concert, where
I don't think they acted
They
in
didn't
concert.
act.
It was a conversation on a public access. You're giving us, them, everybody a little too much
when
credit.
you're having a conversation on public access and your panelist says, "Is it tampering with a government government record?" Yes.
So that was someone was speculated. If I recall that part of the conversation.
I asked that question.
Yeah, Murray was saying if that happened.
That's Miss Maselli's quote.
If
Was
that
it me
happened,
that asked the question? I think I recall asking the question. Because, and I ask it to you now, is it? If you were putting something into a judgment that didn't happen or is false, what do you call
It
it?
depends on whether or not it was done willfully and intentionally, or whether or not it was the result of a mistake.
negligence or recklessness,
Well,
that we're talking about?
it has to be willful and intentional for it to be a crime.
Right.
And that's
You're
what
saying
and that's
it
what
wouldn't
she
be a crime
said.
if it was just reckless or negligent.
Yeah, she said the clerk's office. It's not a mistake. It's deliberate.
Okay.
And she simply made a mistake. And what she made the mistake was that she thought that the language of having conducted an inquiry into the defendant's ability to pay was properly taken out of a judgment and then criminally put back in, when in reality, which Ms. Hopper will be able to show, it never left. They just missed it. And she formed the erroneous opinion that it was a deliberate act, which would, if it was a deliberate act, it would constitute tampering with a government document.
And I think that's what Murray's question was.
Do you think
if
she had
that's
probable
true,
cause to believe that it could have been one? Though?
Exactly.
Because contemporaneously, and I may be using that word wrong, at the time that she is trying to address this issue, she's also doing these PIA requests. And she was very clear on the show that she believed that she was being stonewalled. And as someone who has done a PIA request through your office and was most definitely stonewalled all the way up to the Court of Criminal Appeals, I never thought I'd be on the same side of a lawsuit as Ken Paxton. But there's not a great track record sometimes of complying with PIA requests, and you've got to admit that enhances suspicion sometimes.
She made, by their own admission, like 100 PIA requests. To try to locate the alleged conspiracy, and they came up with nothing. Now there's two theories of why they came up with nothing. One would be that there's some vast conspiracy to keep the conspiracy to put the language back into to criminally put the language back into the judgment and to keep that from the public. And the other is that it was a mistake, and there's nothing for them to find. The reason why they weren't able to get any kind of evidence of a conspiracy is because there was no conspiracy. There was, and so they can file as many PIA requests as they want. They're looking for something that doesn't exist.
Okay.
You've prosecuted conspiracy cases before, right?
Yes.
They can have conspiracies that are small with just a couple people, right? They don't have to be vast.
True.
Right? And that is something that officers of the court pursue to find out if that's something that's going on, right?
Certainly.
Okay. And we've already said that I think you agreed earlier that you could see why some people might have started to think that this kind of stunk a little bit and poked around some. Right?
I didn't say that.
Okay. I want to ask something that you said earlier, Ms. Baldwin. You said that, and I'm rewinding a bit, but you said that someone came down and told us that when people are convicted of felonies, they're not allowed to have a gun anymore, or something along those lines. I don't want to direct quote you.
No.
But
As far as legislative reviews and things like that, a lot of things are come to our attention, whether it's from OCA or,
So that's what I want to get at, is who comes down and tells y'all what needs to be?
Whatever legislation is coming through. We review legislation.
But then who comes and tells you this is what the legislation means or what you're supposed to do? Like, how do those decisions get made? I don't know how the sausage is made. I'm curious.
Well, I'm not part of that particular committee. All I know is that when there's a legislative year, that there's a lot of legislation that comes through. And it is read through, it's filtered. Does it impact our office? Does it not impact our office? What sections do it impact, if it does, and what do we need to do about it?
So how many people are there that would be the person that types in that weapons paragraph that we're talking about earlier into the judgment?
It's not something that's typed in, it's an actual language from legislation, I believe. I wasn't prepared to bring that information, but I believe that it states something to the effect of, if they were convicted of a felony, that there's a firearms admonishment. If they're convicted of a misdemeanor, only in the event of particular type of misdemeanor charges or something like that. Like I said, it was brought to my attention one time, and that's when I told them, don't mirror that into the judgments, and I will check on that again.
And we could check on the wording, but either way, you would agree with me that a signature represents that this person has been provided with that information and is acknowledging it with their signature.
If they're signing plea papers, absolutely.
But they're signing
and it's
plea
not
papers,
on the plea papers.
but then it's being applied to something else. And the only reason I bring that up is because there is some level of distrust in the clerk's office, quite frankly. And I think that Janie was certainly bringing that up, and she was basing it on the information that she saw. And you're here, David, to say that that's wrong. And as I said,
there's proof that I can provide.
And I'm not
viewers.
disputing that. Okay. I'm not disputing that there's proof that was erroneous, that was a clerk, but that was a clerical error or a mistake. I'm not saying that wasn't wrong, but we live in a profession where we make calls all the time that we may not have the proof for beyond a reasonable doubt until we get to the show. To the trial. But
when one lawyer accuses other lawyers of committing crimes, they need to be sure and not just speculating when they're doing it on TV and they're publishing it, because it can turn your production into a defamacast.
Well, I don't think that happened. I appreciate you looking out for reasonable doubt, but it's going to survive long past all of us. I think that's a good. I think that you, in the position that you have as one of the most powerful people in law enforcement in Harris County, should have the position that I need to be careful of who I make accusations against.
Absolutely.
But Janie Maselli Wood and Ted Wood they're not law enforcement. So they come on and say what they think, and I fully support anybody come on and say what they think. And if they can't back it up, they can't back it up. But that's why at the end of the credits, it says that the views expressed and the statements made by the people on the show, including the hosts, are those of their individual people, and they are not representing HCCLA or even reasonable doubt. So I guess I could understand why you're upset that you feel like someone accused you of something, again, I've been falsely accused of things plenty of times that I was very upset by. Now I'm just gonna roll with some of it and go, you know, I know the truth. It doesn't matter to me whether you do or not. But you know, I gotta admit, like, when we started hearing about your concerns with the show, it started making me think that that they were onto something. Because you shined a huge light. You took one of, like, a show that probably nobody would have ever gone back and looked at. And last I looked, it had like over 7,000 views. And I've got people from all over different counties and stuff that have been saying things about this episode, and no one paid any attention to it until you started shining a light on it. And so and I'm being straight up, like, totally honest. I don't know anything about any of this stuff other than what's been told by Janie and by you now. But I'm also like, gosh, David is really feels very strongly about this.
I feel it needs to be cleared up, Justin.
How many times have you seen police officers interview, like, my
Hooper
clients and your former clients, and they say, you're lawyering up, oh, he must be guilty. And you've lawyered up before there's even anything to lawyer up on.
Well, I disagree on that.
I disagree when police officers say it to my clients, but which part? You disagree that with what officers say that, or you disagree that you've lawyered up?
I don't think I've prematurely lawyered up, and to seek advice of counsel, I don't think is a high crime or misdemeanor.
You had counsel reach out to us.
Did counsel reach out to you?
You had counsel reach out to us.
Counsel spoke with Murray.
Right.
So what?
It's more than you consulting with counsel. You're represented by counsel. And all I'm saying is, you have every right to do that. And again, I disagree with police officers when they approach my clients with that kind of mentality. But can you not see why we're all kind of like, this is a little bit bizarre to us?
Well, I just want it cleared up that neither I, nor my wife, nor the clerk's office, nor anybody at the district attorney's office is tampered with a government document.
But you can only speak for you.
Okay, but okay.
And you did that 25 minutes ago.
Okay.
So let's say okay to that.
Okay.
Okay, you didn't do it. You're innocent. You know, and we don't need to belabor that point, because I think that you all know stuff that Justin and I may not know about that. But I think that we can agree that if there was something going on, there was a right to try to correct it. That's what we do in this business.
Exactly, and it was corrected as soon as the mistake was discovered.
And you would agree with me that there's a difference between Janie and Ted Wood sitting over a Scrabble game at home and saying, let's go sock it to David and Judith and let's make some stuff up and go on the show. These are things that they were looking into, and that they should look into. And even if they get it wrong, they didn't seem to target you because you cut them off in traffic or something like that. This was something that they identified as a legitimate issue. And just saying, for the sake of the argument, if it had been, they should have looked into that.
I don't have a problem with them looking into it. They just made a mistake in their conclusion that it was an intentional, willful tampering with a government document, as opposed to a clerical error in a human mistake.
Well, here I have a question coming in.
There's documents where we can prove it, and that's why I'm
here. Then here's a question.
Let's just get on to.
But let's just accept that as true, that those documents exist. Let's
Well, then they should cease and desist with their allegations of criminal conduct.
We have a call waiting. Go ahead and put that. Wait.
So
okay, hang on. Hold on to that call. You're saying that they're still continuing it.
As of this afternoon.
This was a show a month ago.
Right.
And now you want to police what they are saying in their private conversations?
I just want them to cease and desist.
Well, you're going to need your lawyer for that, because I don't control what happens to our guests after they leave the show.
No, I'm not asking you to cease and desist, Murray. I'm asking...
All right. We've got a caller coming in.
Can we
go ahead and put them through, Mark.
Yeah, well,
explain what we do?
I just want to say first that this is the worst episode of Reasonable Doubt that I've seen in my whole life.
Thank you, Franklin.
And I think it's really a disgrace to have Mr. Mitcham on here, who obviously is at this point, listening to him, as bad a lawyer as he is a person, and he's probably, in my mind, the worst person in the world.
Franklin.
And so hold on. But I have a question. You let him talk all night. Now I have a question for David. Hey, David, do you remember when you told the State Commission on Judicial Conduct in writing that I have a mental illness? And I'd like to know your comments about whether that's defamatory, and I'll hang up and listen.
You have been admonished and reprimanded by the Commission on Judicial Conduct. You were a disgrace when you were on the bench, and you have been reprimanded like no other judge in the history of the state of Texas. And yes, I did, because we were concerned about your activities on the bench that were so totally unfit.
But you diagnosed him with a mental illness in writing in a document?
I didn't diagnose him whatsoever. We alerted the commission as to his unfitness for office. And they agreed.
You wrote the document, right? Your name was signed at the top.
It's my name on it. Yes, I am the named complainer.
It made an allegation that he had mental illness without, I mean, y'all having any basis to make that allegation, right?
We have all kinds of basis for his conduct. For his conduct on the bench.
Medical.
For his,
I mean, David, just talking to intellectual. David, you're
not allowing me to get to the heart of the matter that you agreed that I could respond to.
We told you.
I did.
We did.
We just said, okay.
We also stipulate. So from your point of view, you stipulate that we do have proof that this was a mistake and not a deliberate act.
I am saying that I don't have any reason to argue against that, and you wanted to come in and say that, and you have.
All right.
And I also told you that we're opening the doors, and if we have people that are on Zoom that want to talk, and if people want to call in, we won't let Franklin call back in. But
okay. Well, we both have to play it as it lays. I get that.
But at the end of the day, I don't know what else. I mean, I've gotten plenty of dismissals in my time. I haven't ever had you or Kim come down and say, you got us on that one. We were really wrong about that. Sorry about that. And we'll stipulate to it. I mean, and I don't think, it kind of bugs me a little bit, just being honest, that you said as a lawyer to another lawyer, well, what did we just see with Franklin calling in? I mean, we're not that special being lawyers.
We're under certain ethical obligations.
We are, but but some of those things can sometimes conflict, including being officers of the court. If we believe that there's something wrong being done in court, having a duty to respond to that.
I'm not contending that Mr. and Miss Wood or Chris Daniel were lying. I think that
they were wrong.
I'm just saying that they were wrong.
Okay, and we are not here to contradict that. I don't think that anybody would tune into a show to watch that entire debate.
Sure.
But if you want the ability to say that they were wrong, I welcome that. I mean, if a mistake was made,
it's just not saying that it's wrong. I can show that it's wrong.
Okay, but no one's contradicting you at this point.
That's true.
That part's true. Thing. And quite frankly, we don't really have the time or interest to try to contradict you. I mean, this was what started off as a dry episode on August 29th that has been given a lot more interesting leverage by you.
Well, it was a dry episode from your point of view, I suppose. But then when Chris Daniels says a certain chief of staff thought they knew best because of their criminal background and because who their husband is, and they decided the language was necessary, so they decided to fix the issue themselves instead of following what the OCA has promulgated to the entire state of Texas. That is flatly untrue.
Well, so when the OCA sends down, because I got a question about that, when the OCA sends down these new judgments, this is kind of what I was trying to understand from Ms. Baldwin is okay, Troy, so how could the document from the OCA that had the other corrections but did not have the inability to pay language have the inability to pay language appear unless someone added it? That's what I'm trying to understand.
Okay, Cliff Notes version is this. First of all, OCA has these forms. We do not download their forms and put them in our system to use. The forms that we have are literally programmed. Each field is programmed. So although there was 68 individual changes for the 7 judgments in total, if we were to download that particular form into our system, it would equate to 3,395 changes because each individual form is programmed.
Through the whole
so the propensity or the possibility of human error exponentially increases if we were to do it that way.
Okay.
We have this form, it's pre-programmed. We take
What's
a
the
look.
program?
It literally, it'll pull the case number, defendant name, when they were charged, whether it was indictment, information.
Is it like y'all's software?
Yes, it's
Okay,
internal software, which Tracy
I
can
will
speak
explain.
on. So when we have changes or when we're notified of changes in the forms, we literally document to document, find the changes, remove the comma, add these 2 words, or insert or remove whatever language that the Texas OCA form has. When I have 2 clerks with 44 years experience in doing this, this isn't something that's new. Mr. Daniel, when he was in the district clerk's office, this is the same process we did even when he was district clerk. We have it, they go line by line, they make the changes in our system so that way the formulas and everything that's programmed in these forms, like I said, 3,395 changes, has less human error. Did it happen? Yes, it did. Because as they were going through line by line, that one line was missed in error. It wasn't anything that they removed and then put back in for no reason. My chief deputy wasn't even aware of this issue till the day after I got it fixed. As soon as it was brought to my attention, my thing is, I fix it right away, then I notified her. And she even just said, well, how come you didn't let me know from the beginning what was going on?
Who's calling you? Who has authority to tell you, because you're really high up, who has authority to tell you to go in and change that thing for you to be able to go do that?
Texas OCA.
So they call you and go, we found this
No.
thing?
When we are made aware of any form changes with the Texas OCA website, we know that we have to go in and make those changes.
I'm just talking about like when you got that call and you said, I made that change before my chief deputy even notified him.
Janie Maselli is the one who contacted me. Okay. Actually, it wasn't. It was Andrew Smith, and it was an originating email from Janie Maselli to Judge Tiava Bell, who then was forwarded to Andrew Smith. Then I received the information with all of the originating information.
So then you're like, wait, let me
take
go
a
see if
look.
that's right.
Correct.
And then you go look at the OCA form, the current Harris County District Clerk form. You're like, oh shoot,
let's fix it.
Clerical error / negligence or recklessness.
We do have a question from Zoom, which I want to see if that works. Mark, it looks like Sonia Butts has a question.
There's a hand up.
There's a hand
up.
up.
Mouse. It's a mouse.
Oh, it's the mouse.
Sorry.
Never mind. Sorry about that.
Sorry.
All right.
My question's apparently very boring and dull.
Well, no, I just wanted to do this.
I just like to know kind of like who's on the other end of that bat phone sometimes.
Right.
You know, and
we're obligated to follow the forms that the Texas OCA puts on their website.
Right.
And
so
we have an
you find out
effective
about
date.
this and then you went and checked it out yourself.
I looked at it, I said, this was missed.
Okay.
And let's fix it. It was fixed within 3 hours and updated to every single court that uses those forms.
So you, within the district clerk's office, have the authority to like find that error and actually make the change or dictate that the change be made?
Correct, based on what the standardized forms.
I'm not saying you go write the law, but when you realize
Correct.
we made a mistake,
yes.
you're someone, because the clerks I deal with every day, they couldn't go in there and make that change.
And IT has nothing to do with it either. And I know that her name and her team was brought up, but this isn't something that they handle. This is something that on my level, I handle. I even went to Austin and Waco when Mr. Woods was in Texas OCA promulgating the previous judgments. So I represented the office. It wasn't his legal counsel. It wasn't his chief deputy. It wasn't IT. It was me. I went. And so he knew that, well, I don't know if he remembers, but he, you know, that was my job, is to make sure that these forms are updated. And it's all of our internal court forms, the court forms that are used, that are on the attorney kiosk, all of those that are form filled are ones that we have in our documents library. These are the things that we maintain. We remove commas, we add commas. If legislation changes and an article number changes, and that information is brought to us that we have to do it, either the judges, we've had roundtables with judges and other agencies to come in and go over the competency forms. And so it's a collaborative effort on a lot of the different forms. They could be forms from even just DCA or CCCL that have to be done. And we do the same thing. They're pre-programmed. It takes a lot of effort to program these forms. So we use our standard and we make whatever little changes that need to be changed because it's less of an opportunity for human error than it would be to completely start and reinvent the wheel.
Makes sense.
So So for my knowledge, so when I heard about this, I said, well, let's go find out what information changed, what sort of modifications have been made to the form, because every single time Christine's staff modifies this form, that information is saved in our database. And so each version of this document is saved in our database, and I had one of our programmers go into the database. I said, pull out every version that was changed in 2023, save that to a folder so I can review it. And then I went ahead and said, go ahead and give me all the versions through March 6th of 2024 when she actually fixed the clerical error. So when my programmer put these forms into the folder for my review, I looked at the change before. The only two changes in 2023 to start off was July the 3rd and July the 10th. The version before that was actually done on September the 8th of 2020. And so that version, and there was an example of that form in a public judgment for a criminal case on June the 30th, where that information is there in the form. I highlighted it here. So this is June the 30th of 2023. And then the next version of the document, which is the version that she told her staff, go and update the information from the OCA form. Nothing that we get involved with. Her staff goes in and changes the text. Not the programming, not the keywords that populate the form, that when it merges, you know, you get your case number that shows up.
And Tracy, I don't want to rush you, but we got 30 seconds left on the show. So.
Anyway, just to say,
goes by.
It does.
The highlighted information is here. It remained on the form throughout.
It's fixed now.
It is fixed now, yes.
But all these,
but it remained on the form because they forgot to take it out.
And
it's a clerical
when you
error.
find all this and you're sending stuff, all this is in email.
Not necessarily. The clerks that I talk to are literally 2 offices down from me.
No, we don't put anything in an email. But saying it was removed and added back in is false. Everything that I found in our records show that that statement was just never removed.
Okay.
I gotta ask
all right, they're rolling credits on us, Justin. So thank you for, thanks for. That's the first time that I've had them actually. We got played off like
usually
at the Oscars.
Like start with rap now with 4 exclamation marks. That still says 30 seconds.
Well, I know you had a lot more to say, but
are we off the air? Are we on the air? Or what?
Still on, but it's.
Well, what I would have brought to your attention, Murray, if had we whirled in time, was that what was asked today at the attorney forum over at the clerk's office from Janie Maselli. And the question was, this is supposed to be a question about the clerk's office. This is her question. Address the district clerk's modification of the standardized felony judgment form, which was added language that OCA had deleted. This refers to the ability to pay inquiry language, which was added July 14th, 2023, and was not deleted till March 2024. That's not true.
Nothing happened.
And she continues to broadcast this within the community, and it's an error. And I wanted to bring it forward and just cease and desist.
Are we still on, Mark?
Yeah, I'm about to.
Yeah, I think we can. I don't think.
Well, before you cut it, there was other things I wanted to talk about too. Did you actually go into a meeting with the county court judges and tell them they had to get in line with Kim Ogg's agenda, or there would be consequences?
Not to use.
That's one thing. That has been repeated multiple times.
Well, no, it wasn't. It wasn't county court judges.
I always heard district.
It was
district court judges.
They were district court judges.
And you told them.
And I did not use that language. No, I didn't use that. I said that they had to. I addressed the issue, and someone needs to have a program addressing this issue.
Will you come back and talk about it more?
About bail reform?
Well, no, about
because that's what we were talking about.
And then, like,
we were talking about bail reform.
If you handpicked ADAs to run against other judges in Democratic primaries, will you come back?